The more we see the wordings of our constitution, the more we get mesmerized by its beauty. Article 14 is one of the most important fundamental rights, and it is a part of right to equality, which is covered from Article 14 to Article 18. Article 14 says that the state shall not deny to any person equality before law or equal protection of laws within the territory of India. Now, see these beautiful expressions: equality before law, equal protection of laws. While one is a negative concept, another is a positive concept. And the state provides this fundamental right to each and every person. The phrase any person includes citizens, foreigners, legal persons, companies, corporations, registered societies. So the ambit is big enough to get this Article 14 available to all these persons. But it does not include any enemy alien. The basic understanding lies in these two expressions. Equality before law is a negative concept which has British origin. It simply says that the Prime Minister, advocate, cobbler, farmer, every person from every strata of the society, they are at the same pedestal. It means the absence of any special privilege. All are equally subjected to the law of the land. And that also means that no person is above the law. Previously, there was a concept that the king can do no wrong. But equality before the law negates this kind of medieval concept and subjects every person within the purview of law. It is a negative concept because no special protection is given to any kind of person, whether he is a prime minister, whether he is advocate or farmer or teacher. No one is given any kind of special protection. But this concept is not complete in itself because India has a diverse population and people needs upliftment. The historically downtrodden people had a dream that the independence of India will uplift them and connect them to the mainstream of the society. The aspirations of these people needs to be protected, and this resulted in a positive concept which is equal protection of laws. Essentially, it is taken from the US Constitution and applied in the Indian democracy. So the concept is like should be treated alike without any discrimination. The people who are in the similar conditions, law will treat them alike. Similar application of same laws to similarly situated persons. This also means equality of treatment under equal circumstances, both in the case of privilege and liabilities imposed by law. If you see the whole arrangement of Article 14, there are laws made by the state for the upliftment of people, but that laws should not be discriminatory because Article 14 forbids class legislation and permits reasonable classification. The state will make laws and can make laws by classifying a particular section of people for their upliftment. But that classification must not be arbitrary or evasive. It has to be reasonable. And when we shall say that a classification is reasonable, will be based on two tests which is given by the Supreme Court in the case law State of West Bengal versus Anwar Ali Sarkar 1952. First, the classification must be founded on intelligible differentia. And second, the differentia must have a rational nexus. So the first point is saying that the classified persons or the things must be distinguished from the remaining others which are left out. And the second says that there must be a relation to the object sought to be achieved by that law. Meaning, if there is any particular object like the welfare of the state, the law must fulfill that object. Now, here you have to remember that Article 14 is a base article which has to be remembered and understood with other articles of the Constitution. It is interconnected with the other articles and it is a part of the golden triangle of the Indian Constitution, which is often referred to Article 14, 19, and 21, which collectively guarantee equality, freedom, and life, protecting against the arbitrary state action. There are several Supreme Court judgments which clarifies that they are the basic structure. Now this principle of equality, there are some exceptions to it. These exceptions are important for the normal functioning of state. Few people are included in these exceptions so that they can function, they can do their duty efficiently. There is our president and the governor who are given some immunities when they are exercising the duties of their office. They are not answerable to any court. No criminal proceeding shall be instituted during their term of office. No process of arrest or imprisonment during their term of office. And there is no civil proceeding without a 2 months prior notice. Again, Article 361A gives our journalist protection against any civil or criminal proceedings in any court for the publication in newspaper or radio or TV of a substantially true report of any proceedings of either house of the parliament or state legislature. Again, the member of the parliament and the members of the legislature of a state, that is, the MPs and MLAs, are given protection from any court proceeding on anything said in the parliament or any vote given in the parliament or the state legislature. Again, Article 31C is an exception. The Supreme Court has said where Article 31C comes in, Article 14 goes out. And there are some exceptions given to the foreign sovereigns, ambassadors, diplomat from criminal and civil proceedings. They are given some kind of immunity so that they can function properly. Again, when there is any emergency, when a proclamation of emergency is in operation, the President may suspend the right conferred by Part 3 and therefore the enforcement of Article 14 may be suspended during the emergency. This was a very basic understanding of Article 14, where we have categorically discussed the main expressions, the main keywords, and the related case laws, doctrines, and also the exceptions. To participate in this discussion and leave an imprint, please comment in this video and subscribe to the channel for such engaging content. Thank you very much.